The contract was 12 pages long. My brother had paid a lawyer $400 an hour to draft it. He had printed it on heavyweight bond paper. He had organized it into tabbed sections with colored dividers, the kind of presentation that says I have been preparing this for a long time and I would like you to feel the weight of that preparation. He slid it across the plaintiff's table in Courtroom 4B on a Tuesday morning in November and told the judge it represented the founding agreement of Harlow Creative Solutions, the company I had built from a single laptop and a folding table in my spare bedroom over the course of 6 years. His name was on the cover page as founder. My name appeared on page 3, line 8, as a contracted service provider with no equity stake or ownership claim. He looked at me from across the aisle with the expression of a man who had already spent the settlement money. He had one problem. I had written that contract. Every word of it. Before I tell you what the judge said when she read page 11, drop a comment and tell me where you're watching from. I want to know how far this story travels. My name is Claire. I'm 33 years old. To my brother Ryan, I have always been the younger sister who was good with computers. The one who stayed in on weekends. The one who didn't play sports or run with the right crowd or make the kind of impression that got remembered at family dinners. The one my father once described, not unkindly, as quietly capable. Quietly capable. I built a $3.8 million creative agency on Quietly Capable. I built it on 6 years of 18-hour days and a client roster that grew entirely through referrals because the work was that good. I built it on a team of 11 people who trusted me to make payroll, to fight for their salaries, to build something that would still be standing in 10 years. I am also, as of 3 years ago, a licensed attorney. I passed the bar on my first attempt while simultaneously managing 2 major client accounts and a company rebrand. I did not advertise this widely. I kept it in my back pocket the way you keep an umbrella when the sky looks uncertain. Ryan had known about the law license for exactly as long as it had been convenient for him to forget it. To understand what happened in Courtroom 4B, you have to understand the specific geography of growing up as Ryan Harlow's younger sister. Ryan was the eldest. The golden one. He had our father's jawline and our mother's social ease and the particular confidence of someone who had never once been told that what they wanted was unreasonable. He had sailed through school on charm and athletic ability. He had started 3 businesses in his 20s, each of which had collapsed within 18 months, each of which our parents had quietly absorbed the losses from without discussion. He was, in the language of our family, a big picture person. Someone with vision. Someone who needed the right support structure around him to truly flourish. I was the support structure. I had understood this about my family's dynamic since I was approximately 14 years old. I was the one who proofread Ryan's college essays. I was the one who built the website for his first business and managed his social media for his second and drafted the investor deck for his third. I did all of this because I loved him and because the family architecture rewarded contribution with inclusion and I wanted, more than I had ever admitted to anyone, to be included. The last business, a lifestyle media company he had called Apex Creative, had failed spectacularly in 2019, taking $180,000 of our parents' savings with it. I had watched that collapse from a careful distance, having declined to be formally involved after recognizing the structural problems in the first 6 weeks. 6 months after Apex folded, Ryan called me. He said he had a new idea. He said he had learned from his mistakes. He said he thought we should build something together, that my skills and his vision were a natural combination, that this time it would be different. I said I would think about it. What I did instead was start Harlow Creative Solutions on my own. Quietly. Without telling him. I did not do this out of cruelty. I did it because I had spent 29 years being Ryan's support structure and I wanted, once, to build something that was entirely mine. Something where my name was on the founding documents and the bank account and the decision-making authority and every single thing that mattered. I registered the company. I drafted the operating agreement myself, Because I had just completed my second year of law school and because I trusted my own precision more than I trusted anyone else's. I named myself sole founder, sole owner, and managing director. I built the client list. I hired the team. I ran every meeting, signed every contract, made every decision. For 2 years, the company grew quietly and steadily and entirely without Ryan's knowledge. Then our mother mentioned it at Christmas dinner. Ryan called me on December 27th. He said he had heard about Harlow Creative. He said he was proud of me. He said it sounded like exactly the kind of thing he had always imagined us doing together. He said he wanted to be involved. I told him the company was fully operational and not currently seeking partners. He said he understood. He said he just wanted to help. He said he had contacts, relationships, industry experience that could accelerate our growth. He said he wasn't asking for much, just a seat at the table, a title, something that reflected his contribution. I told him I would think about it. Over the next 4 months, Ryan inserted himself with the patient persistence of a man who understood that incremental presence eventually becomes assumed belonging. He started showing up to client events I mentioned in passing. He began introducing himself at industry functions as co-founder of Harlow Creative. He sent emails to 2 of my existing clients on company letterhead he had designed himself, which I did not discover until one of those clients forwarded the thread to me with a question about your partner Ryan's proposal. I called him. I told him clearly and without ambiguity that he was not a partner, not a co-founder, not affiliated with Harlow Creative in any official capacity, and that if he contacted my clients again representing himself as such I would take legal action. He went quiet for 6 weeks. Then he filed suit. The complaint alleged that Harlow Creative Solutions had been founded as a joint venture between Ryan Harlow and Claire Harlow in 2020, that I had misappropriated the company's founding concept and client relationships from a prior verbal agreement between us, and that he was entitled to 50% equity, back compensation, and damages. Attached to the complaint was the contract. 12 pages. Tabbed and color-coded. Bearing both our names. My name on page 3, line 8, as a contracted service provider. His name on the cover page as founder. I sat with that document for a long time. Then I opened my files. Here is what Ryan did not know, or had chosen to forget. I had drafted every founding document for Harlow Creative Solutions myself. Every operating agreement, every client contract template, every vendor agreement, every employment offer letter. I had drafted them because I was a law student and later a licensed attorney and because I am constitutionally incapable of allowing important documents to be handled by anyone else. Every document I had ever drafted contained something Ryan had never thought to look for. A version history. Every document in my system was maintained with full metadata, creation date, modification timestamps, author credentials, revision log. This is standard practice in legal document management. It is invisible to anyone who does not know to look for it. The founding operating agreement for Harlow Creative Solutions had been created on March 14, 2020 at 11:47 p.m. The author was listed as Claire M. Harlow, J.D. candidate. It had been modified 4 times over the following 2 weeks, all by the same author. It had never been shared with Ryan Harlow. It had never listed Ryan Harlow as a party. The contract Ryan had presented to the court had been created on September 3rd of this year. 4 weeks before he filed suit. The metadata, which his $400 an hour attorney had apparently not thought to examine, showed it had been authored by a paralegal at his law firm, modified twice, and finalized 11 days before filing. It had never existed before this lawsuit. He had not found a founding agreement. He had manufactured one. I called my attorney, a woman named Patricia who had 30 years of commercial litigation experience and the specific unhurried confidence of someone who has won enough times to stop performing urgency. I told her what I had. She was quiet for a moment. Then she said, he filed a fabricated document in a civil proceeding. That's not just a losing case, Claire. That's potential fraud on the court. I said I was aware. She asked me what I wanted. I told her I wanted it done in one hearing. Courtroom 4B was smaller than I expected. Wood paneling, fluorescent lighting, the particular stillness of a room that has absorbed 1,000 arguments and remains entirely unmoved by all of them. Ryan arrived with his attorney, a man named Garrett who had an expensive suit and the practiced ease of someone accustomed to cases where the documents were real. Ryan was dressed carefully. He looked confident the way people look confident when they have convinced themselves the story they are telling is true. He did not look at me when he sat down. Patricia set her briefcase on the table with the unhurried precision of a woman who was not afraid of this room. The judge, the Honorable Sandra Okafor, had been on the bench for 19 years. She had reviewed the complaint and the attached contract before we arrived. She opened the proceeding by noting that this was a dispute over founding documentation and equity rights in a privately held company and asked the plaintiff's counsel to walk her through the basis of the claim. Garrett did. He was good. He spoke clearly and organized his argument well and presented the 12-page contract with the confidence of a man who believed in what he was holding. He described a founding partnership, a verbal agreement, a pattern of joint contribution. Judge Okafor listened without expression. When Garrett finished, she turned to Patricia. Patricia stood up. She said, "Your Honor, before we address the substance of the claim, I'd like to introduce a technical exhibit into the record." She placed a single document on the plaintiff's table. It was a metadata report. Forensically extracted, professionally formatted, certified by a digital forensics firm whose letterhead the judge recognized. Patricia walked through it in 4 sentences. The founding operating agreement for Harlow Creative Solutions, created March 14, 2020. Author, Claire M. Harlow. Never modified to include a second party. Never shared with the plaintiff. The contract submitted by the plaintiff, created September 3 of this year. Authored by a paralegal at the plaintiff's law firm. First appearance in any document system, 31 days ago. She placed a second document. The original operating agreement, with full version history attached. She placed a third document. The company's certificate of formation, filed with the state on March 17, 2020. Sole founder listed, Claire M. Harlow. She placed a fourth document. 3 years of tax filings, all under Claire M. Harlow's sole proprietorship. She placed a fifth. The bar admission record for Claire M. Harlow, licensed attorney, showing admission date of June 2021. Confirming she had the legal knowledge and capacity to draft founding documents herself from the outset. The room was very quiet. Garrett leaned over and spoke in a low voice to Ryan. Ryan shook his head. Garrett spoke again, more firmly. Ryan looked at the documents on the table and I watched something happen in his face that I had not seen before. Not in 33 years of being his younger sister. I watched the story he had been telling himself run out of road. Judge Okafor looked at the metadata report for a long moment. She looked at Garrett. She said, "Counsel, I'd like you to explain the discrepancy between the creation date on this document and the founding date of the company." Garrett said he would need a brief recess to confer with his client. The judge said, "I'll give you 10 minutes." They came back in 7. Garrett requested a voluntary dismissal of the complaint. Judge Okafor granted it. Then she looked at him over her glasses and said that given the nature of the documentary discrepancy, the court would be referring the matter to the State Bar's disciplinary committee for review of the submitted exhibit. She looked at Ryan directly. She said, "Sir, submitting a fabricated document in a civil proceeding carries consequences that extend beyond this courtroom. I would strongly encourage you to seek independent counsel regarding your exposure." Ryan said nothing. He did not look at me on the way out. I sat at the defense table for a moment after the room had cleared, hands flat on the surface, feeling the particular stillness of something that is finished. Patricia packed her briefcase with the same unhurried precision she had unpacked it with. She said, "That went well." I said, "He really thought he had me." She said, "They always think that. Right up until the metadata." I called my mother that evening. She had known about the lawsuit. She had not taken sides, which was the closest thing to neutrality she had ever managed where Ryan was concerned, and I had chosen to receive it as love. She asked how it went. I told her it was resolved. She asked if Ryan was okay. I sat with that question for a moment. The way I had learned to sit with questions that contained several other questions inside them. I told her I didn't know. I told her that was something Ryan would have to figure out on his own timeline, and that my timeline had its own requirements. She was quiet. Then she said, "I know we didn't always make it easy for you." I said, "No. You didn't." She said, "You turned out anyway." I said, "I turned out because of the work I put in. That's the part one need you to understand." She said she understood. I don't know if she fully did. But she said it, and sometimes the saying is the beginning of the understanding, and I have learned to give people room to catch up. The disciplinary referral is still under review. These things move slowly. I have stopped checking. Harlow Creative Solutions filed its best revenue quarter on record 2 months after the dismissal. 11 employees. 14 active clients. A new office lease in a building I chose myself, signed by me, with my name on every page. Ryan has not contacted me since the courthouse steps. I have not contacted him. I keep the original founding operating agreement in a fireproof file in my office. Not because I need it anymore, but because sometimes you need to be able to hold the thing you built and remember exactly when you decided to stop waiting for permission to own it. My name is on page 1, line 1. It always was.